part of a team that works on issues touching on New York State government. The Brennan Center is a nonpartisan law and policy institute, and as such, we look forward to working with officials from all parties for positive ethics reforms. We are delighted to be part of the first ever interactive forum on this topic here in Albany. The anticipated ethics reform bills are going to be complicated measures with multiple moving parts. As much sunlight as possible will be required to ensure that everything works as intended. My testimony will point out some of the unintended consequences of past efforts at reforms that were adopted without serious scrutiny or debate. Everyone here will probably agree that the package of reforms passed in 2007 has proven to be mostly a dismal failure. At that time, policymakers ignored calls for a powerful, unified commission like the one that we see in Senator Squadron's bill today, which would have overseen all of New York's ethics laws, and instead, without a hearing or a debate, passed a hasty measure that institutionalized the confusing, bifurcated system of oversight that we have today. The Commission on Public Integrity, which oversees executive branch officials and lobbyists, and the separate Legislative Ethics Commission, whose 9 members consist solely of legislators and persons appointed by legislative leadership. It is the Legislative Ethics Commission that has proven especially calcified, ineffective, and, I'm going to say it, dysfunctional. The LEC has never been fully staffed. It currently operates without its 9th member, an outsider who must be jointly appointed by legislative leaders. Perhaps overcome with enthusiasm to pass a bill, supporters of the 2007 reforms did not realize that their important goal of having a majority of outsiders as LEC commissioners could be thwarted in this way, though a default mechanism for this appointment could easily have been included at that time. The LEC's meetings are not public, and perhaps most telling, since its creation in 2007, it has not issued even a single finding against a sitting legislator. Since 2007, the LEC's only substantive public action has been the issuance of a notice of reasonable cause against Senator Hiram Montserrat after he had already been removed from office by the senators themselves. We urge immediate action to reform the current system so that a single unified commission has jurisdiction over all public officials, executive and legislative, as well as lobbyists. The new commission should be given jurisdiction over post-employment compliance, gift and honoraria restrictions, and financial disclosure requirements for all officials. The new commission should also be empowered to investigate all public officials in a thorough and even-handed way, including the power to issue subpoenas and make referrals to appropriate authorities. Before findings are issued or made public, targets should be given an opportunity to address the commission. If any portion of ethics oversight is retained by the legislature, such as determinations and punishment for violations of conflicts of interest rules, then that process must be made much more open to public scrutiny and accountability, with provisions for open meetings and disclosure of the results of votes. If referrals or complaints are not acted upon within a certain period of time, they should be made public. Finally, on this topic, we urge that Unified Ethics Commission be charged with an expansive mission that includes not just oversight and enforcement, but also providing useful guidance, training, and outreach to all officials and their staff members. The Commission on Public Integrity, which watches over executive branch employees and lobbyists, produces a timely annual report and holds regular meetings that at times have been open to the public and even webcast. CPI's professional staff answers questions and issues advisory opinions and regular press releases on its accessible website. It is not a perfect institution, but these are essentially good practices and should be continued and built upon by a new unified commission. Ideally, we would have a commission that is tasked not just with oversight and enforcement, but also the equally important goal of helping everyone conform to very high standards of ethical behavior. My colleagues and I also urge establishment of meaningful financial disclosure of all outside income for public officials. As we pointed out in our study of the need for ethics reform earlier this year, corruption scandals in the state legislature mostly relate to the legislator's receipt or solicitation of undisclosed outside income. And it is disturbing that the ethics laws allow legislators to be partners with persons with lucrative state-related businesses, including law firms and consultants, as we heard earlier. Public officials should disclose all sources of income, including their commercial tenants, sources of brokerage fees and commissions, and other third-party payments and business clients of law firms and other professional practices. A comprehensive list would allow reporters, election challengers, and constituents to evaluate whether a relationship between an official and a client is truly a professional business relationship unrelated to the official's position. In December 2009, my colleague Larry Norden and I wrote a piece published in the Daily News challenging some legislators' assertions that they could not disclose more information about their law practices because their client's identity was protected by attorney-client privilege. Since then, both the New York City Bar and the New York State Bar Association have called for disclosure of client identity for public officials with part-time law practices, citing practices in other states that include proper protection of sensitive client issues. We urge the legislature to fully embrace this concept and avoid the temptation to adopt a half measure, such as disclosure of only clients with business before the state. Recent scandals involving subtle influence peddling have shown that more information, not less, is needed. In conclusion, I must emphasize one additional very important point. As critical as the ethics reforms we are discussing today are, the Brennan Center believes, based on our study of ethical lapses in New York State government, as well as successful efforts to transform corrupt governing elsewhere in the nation, that a package of campaign finance reform is essential to restoring public integrity. New York State's campaign finance system has been called disgraceful by independent analysts and the public at large. Indefensibly high contribution limits, coupled with utterly inadequate disclosure requirements and non-existent enforcement, have created a system that cries out for change, starting with the need for establishing a voluntary system of public funding. More information about these issues and our proposals for reform can be found in our report. Thank you for the opportunity to speak today, and we look forward to the next stages of this very important process.